Welcome to Looking at Legal Stuff. Today we have 11 hearings with a couple who have a long history of back and forth in the courts. We will watch as Mom attempts to establish child support after a recent switch in custody. Then she attempts to limit Dad's custody time after a messy public squabble with their daughter that may have crossed a line. And then she files a motion to hold Dad in contempt for not paying his child support on time. Later, we have Dad motioning the court for sole decision-making over their son's extracurricular activities. He says Mom won't let their son attend the rodeo when it lands on her weekends, but Mom says Dad didn't give her enough notice to take time off of work, and besides, she doesn't think their son's recent bad behavior should be rewarded with the rodeo. In today's final update, we have a missing hearing from last autumn where the attorney appointed for their daughter claims that Mom has been preventing contact, and we have a new hearing where Mom is once again motioning the court for a restraining order after an incident between their son and his father. What does the judge have to say to this high-conflict couple? Let's find out.
Okay, let me go to the docket then. Let's first take Kevin Cahill and Sarah Counts. Ms. Gilmore is here. Is Ms. Counts here?
Yes, sir.
Okay, good morning. So we are here on a request to modify child support. Right now, I think it's set at 0 because the parties were had each had one child. That was back in 2019. Ms. Counts is now requesting that be modified. So let's hear from Ms. Counts first, and then I'll go to Ms. Gilmore. Okay.
Okay, so first of all, I received an email yesterday and I just want to object to the filing of those documents as they were not supplied to me in I guess an appropriate amount of time to be filed with the court to be considered. I would also like to just bring up the fact that this is the same excuse that Mr. Cahill used the last time that he tried to stop child support from going forward. He claimed that he had just started his business, the business was struggling. Those are all of the same excuses we're trying to use this time. But Mr. Cahill failed to mention in his paperwork at all that he has expanded his business to open 3 additional businesses.
I have to object at this point. I don't have any declaration supporting this testimony.
All right, first of all, there's been a motion that I exclude the declaration by Mr. Cahill and then I believe a filing showing his income for 2022. I'm going to deny that request. However, Ms. Counts, if you feel you're prejudiced by the timing on it, I'm willing to put this over a week so that you have time to respond to it.
Yes, I guess then that would be,
we can do that.
yes, I guess then that would be the route that I would like to go. Yes, sir.
So you said that's the route you'd like to go. What route is that? The put it over a week?
The continuance, yes, sir.
Okay. I'm just letting some additional people in here. Ms. Gilmore, any objection to putting this over a week?
I acknowledge it's a late filing, so I appreciate that if she needs time to respond to that. I will just note that I'm in Clark County, but I'm also on the court's docket, so I just have to balance next week both of the counties.
Okay, you could send a message in the chat just letting me know what timing you would have.
That's fine.
I appreciate all parties being here. The reason I denied the motion to exclude the documents is the court needs to know what the income is from both parties in order to make a decision. And so it just makes more sense to grant Ms. Counts additional time than it does to exclude those documents. So we'll put Cahill and Counts over to February 1 at 9 o'clock. Okay.
Thank you.
All right.
Thank you, Your Honor.
All right, let's go back to Cahill and Counts, please. See, Ms. Gilmore is here. Mr. Cahill is here and Ms. Jackson is here, I believe. Yep. Okay. We're here to address a child support request by Ms. Jackson. Let me, I guess, tell you what I've gathered from the declarations that have been filed. Mr. Cahill filed a declaration saying in 2019, there was an order entered that because the children were being shared in terms of their residence between the two parties, the court ordered no child support be paid by either party. And that's been the case up until, now. He doesn't feel there's been a substantial change in circumstance that would support awarding child support at this point. Ms. Jackson is coming in saying that she didn't agree to that order back then, that she does feel there's been a substantial change in circumstance in terms of additional income to each party and the fact that the children that were living with the parties have switched, and also the adult children no longer are being supported. So that's what I hear. There's also, I think, some dispute about how much money Mr. Cahill makes. I guess let me tell you my thought, and then I'll let the different parties address that. It's been since 2019. I think there is a substantial change in circumstance. I think just based on the change in income, there is a need to relook at the child support issue. At this point, Mr. Cahill makes substantially more than Ms. Jackson. And so I think there would need to be a transfer payment from him. I can tell you where I think that should be set, but I guess I'll give the parties a chance to, and particularly Ms. Gilmore, to argue the issue of substantial change and whether there should be child support at all.
Yes, Your Honor. I just have massive procedural concerns in this case. I understand that we have a pro se litigant, but they're held to the same standard. So as said before, the court on any case, Washington State is a notice pleading state. Within her motion, she has an obligation to support her case with facts. We literally, in her declaration for her underlying requests for child support, she doesn't even address it. She doesn't even make an allegation of what she's even requesting for. She doesn't present any financial information. She doesn't present any sort of worksheets or request for any sort of transfer payment whatsoever. And then in the 11th hour, literally yesterday, we have new information contained within a reply declaration that goes way outside of the scope of the underlying motion here. So as we stand before the court, my client doesn't have an ability to defend himself without even presenting worksheets. We're before the court without even worksheets. So I don't know how to proceed here. And this is the third hearing on this issue. Again, she has an obligation to present a motion with a declaration asking for a request in addition to worksheets. And my client it's basically a moving target at this point. So I frankly am frustrated by the sense that we still need to procedurally go before the court with a motion timely served with the declaration, and my client should have the ability to adequately represent himself through due process. So I ask the court deny it at this point, or at the very least reserve, and this needs to be addressed either at a final hearing or an additional motion with proper service and a declaration.
All right, Ms. Counts, do you want to address any issues?
I actually do believe that I did file when I filed my original pleadings, I did put in some child support paperwork. I did not have access to Mr. Cahill's income at that time.
Did you provide that to Ms. Gilmore? I know I have sheets.
Yeah, it was directly served to Mr. Cahill. Yes, sir. It was before Ms. Gilmore was representing him, sir.
Okay.
Can you reference where if there is a declaration mentioning incomes or worksheets, can you reference when they were filed?
The original filing back in October when I originally brought motion before the court.
Just give me one second, I'm trying to pull that up. Based on the information I had, the motion itself was just addressing the transfer of custody of Elizabeth. It made no reference whatsoever beyond just the general request within the motion, underlying motion, that she was requesting for a child support order to be entered. That motion didn't even reference the fact that there was a temporary order at that point.
I don't know that it referenced the temporary order. I think I learned that from your declaration. Let me tell you what as I've looked at this, let me tell you what conclusions I made. I'm going to tell you where I'd like to go, and then we'll put this over 1 or 2 weeks to allow both parties to come back and say, no, you shouldn't do that. I think the issue of child support is before me. What I have from Mr. Cahill is a document that shows that he made $90,000 last year. That was till November. I'm going to accept his representation that he did not take a payment in December. Ms. Jackson is represented that she makes $3,700 gross. I went to support calc. That shows that if it were Ms. Jackson making the child support payment, it would be $712.04. If it was Mr. Cahill making the payment, it'd be $1,339.96. But it seems to me, since they each have one child, that those numbers should cancel each other out or be a credit, which leaves a transfer payment from Mr. Cahill to Ms. Jackson of $627.92.
So I can tell, sorry.
And the way I look at that is that is a way to, through this calculation, to ensure that both children have an equal amount of support. The law says that Ms. Jackson should be contributing $712, and Mr. Cahill a bit more. It just seems that that's a way to equal things out for the children.
And respectfully, Your Honor, I don't think that that's necessarily the correct analysis pursuant to statute. I can tell the court that I did run a worksheet for myself, and with the residential split adjustment, that comes out with a transfer payment from my client to mother in the amount of $352.45.
Okay.
And that's setting my client at the 90,000. That's setting her based on her wages we received based on the pay stub.
Okay, so I appreciate that, and what I'd like to do again is put this over a week or two so that you can provide that analysis to me. Ms. Jackson can provide whatever argument she wants to me, and I'll make a determination which way I should go in terms of the amount. But I think today what I'm letting everybody know is I think child support is before me. I think there needs to be a transfer payment from Mr. Cahill to Ms. Jackson because he makes more. I am accepting that his last year's gross amount is $90,000, which accepts he didn't get paid in December. So all of those things I'm accepting today. What I'm not making a decision on is exactly what that transfer payment is going to be. Okay.
And I can get those filed today or tomorrow.
Well, if we put it on next week, that's February 8th. Why don't we do that? Because we basically have most everything in front of me right now. So I'd like to see that, and I'll make a decision on the amount.
And I can present likely a child support order at that point, just knowing the court's ruling, so we can avoid an additional presentation hearing.
That's fine. If you want to submit that too.
Okay, thank you.
All right, Ms. Jackson, can you be back here next week?
Yes, sir, no problem.
And any additional argument you want to make, go ahead and provide a declaration to the court, okay?
Yes, sir, thank you.
All right. All right, we're here for a request for child support. And last time we were here, I indicated I would agree that Mr. Cahill's income was $90,000, that he would owe child support. The issue was how much. I've been provided with a proposed order that includes an addendum. See the addendum, but the addendum where there's a shared residential split shows child support owed of $357. So Ms. Gomar, I assume that's your position at this hearing?
Yes. And then I frankly have never had a case where if there's a resident, if the parties have one child living in one residence and another child living in another residence, that the court hasn't adopted this formula. And that should be on the first page following the child support order, and that breaks down the math of that. But yes, we are asking the court to adopt both the child support order as well as the worksheets. I think the one point of contention, and I don't know Ms. Counts if she's reviewed this, I do apologize, I presented it on Monday, but we are asking that he claims taxes for both children every year, given the fact that he has Neil a vast majority of the time, and he's now paying child support for Elizabeth. So that's the basis of a request regarding taxes.
To the amount of child support and also the tax issue.
I don't have any objection to the amount of child support. It was actually higher than the amount that I got when I did the paperwork myself through the website. I do have an objection to the tax filing. When you read the code for tax filing, it does say that he has to provide Lizzie with 50% of her income or support her for more than 50% of the year. $300 and something is not 50% of the $1,014 that it is accrued for monthly costs for each of the children's living. And so I'd ask that that part be removed. The other thing that I had an issue with is that they set the start date for child support at February 1st. I would ask that that be changed to December 1st, as this was supposed to be ruled on back in December. And it just kept getting pushed over and pushed over. Other than that, I don't have any kind of issue with the paperwork. It all looked in good order to me, sir.
So I'm not going to let the father claim both. So I'm going to make a modification here. In terms of the start date, if there was a delay, that was the court's delay. I don't think that was Mr. Cahill's doing. And I think a February 1st start date is appropriate. So that's when the amount should be paid. So that would be beginning this month. Other than that, I do think the calculation provided by Ms. Gilmore is correct, and I will sign the order.
Can I ask just one clarifying question, please?
Let me just finish getting this ready here.
Thank
okay.
you.
Yes, Ms. Jackson, go ahead.
I was just wondering, are we starting the filing credit for the taxes since we had a swap with the kids? I was just wondering if Mr. Cahill is planning on claiming Elizabeth for last year or Neil, if we should go based on the order that is in place today or the previous order for the tax filing year.
I think that's a really good question. I think the children did not switch really until last year, but I think last year Neil was living with you and Elizabeth with Mr. Cahill. So I think and there was no child support paid during that time. So I think it's appropriate that you each take a deduction for last year. Technically you may claim the opposite child. So Mr. Cahill should claim Elizabeth and Ms. Jackson should claim Neil. And then starting in 2023, the order I just signed would go into effect, where Ms. Jackson would claim Elizabeth and Mr. Cahill would claim Neil.
And that's what I was actually looking for when you were signing the orders I was looking back at the 2019 order and it actually reserved on taxes. So if the parties have filed, I'm assuming it's based on agreement of the parties, but there was previously no order.
Okay, well, I think it's appropriate to do it that way for 2022 and then 2023, the current. And the first case we'll call will be Kevin Cahill and Sarah Counts, I think Sarah Jackson now. And Ms. Gilmore is here. And Ms. Jackson, do you want to unmute yourself? I guess you have. Okay. All right. Ms. Jackson, I think you brought to the court's attention some concerns. So I'm going to let you address those first. Okay.
I said over on this piece, I didn't receive those materials until last week, which isn't timely pursuant to local court rule. Also, I was on vacation and my office was closed on Monday. My client should have the opportunity to respond to those. I think also, I think either party needs to bring forth the children's school records and some more information. I was also just looking for direction from the court. This is on for a review, not necessarily a motion. And so, I'm happy to present declarations and additional evidence if the court's willing to entertain modifications to the parenting plan. I just don't know the procedural basis to that. And so I just needed some more information from the court and I'm asking for a set over.
How long are you asking for?
Frankly, I can turn around and get some materials out this week if the court would like to hear it next week, or alternatively, best for notice to Ms. Counts would be 2 weeks over.
Ms. Jackson, any response to the request for the set over?
No, I don't have any kind of objection to that, no, sir.
All right. So there's two independent declarations describing conduct by Mr. Cahill that is concerning to the court. And I'm not exactly sure what the court will do with that. I need to obviously hear from Mr. Cahill on that point. But if this were a request for a protection order on a temporary basis, it would probably be granted based on those declarations. And I think if I'm going to put this over 2 weeks, just to be absolutely safe and make sure that Elizabeth stays safe, I'm going to suspend visitation during that period. And then we'll take it up in 2 weeks on July 5th and decide how we go from there.
I would just again, this isn't for the court of any sort of motion. I don't think that there is any basis for a sua sponte ruling to terminate visitation. I can update the court that this was reviewed by law enforcement, and law enforcement didn't make any sort of findings of abuse or seek any charges. So I'm asking the court to maintain visitation absent any sort of motion.
All right. Well, again, based on independent declarations that I've received, I'm going to err on the side of caution here. So I am going to suspend visitation as a condition of setting this over to July 5th. And then we'll take it up at that point.
Thank you.
All right. Thank you.
Is that court hearing going to be at 9 a.m.?
That will be at 9 p.m. just on Zoom. Okay,
Yeah.
all right, thank you.
Okay, here we go. All right, looks like Ms. Counts is joining now. Okay, we're here in the matter of Sarah Counts and Kevin Cahill. Cause number is 113764-7. Ms. Counts, can you hear me okay?
Yes, sir.
Okay, and Ms. Gilmore, double check, make sure your microphone's working.
Yes, can you hear me?
Yeah, it's working, great.
Okay, perfect, thank you.
Good. All right, so we had just called the case and there's indication that Ms. Counts is trying to join or is stuck in another Zoom area, but she's here now, so that's great. We're on today for a motion brought by, I guess, are you going by Ms. Jackson now? Okay, so, and it looks like you're muted, Ms. Jackson.
I'm sorry. Yes, my legal name is Jackson, sir.
Okay, so this is Ms. Jackson's motion for restraining order and also related to a potential change in the parenting plan. And so I've reviewed a number of declarations and motions. I read Mr. Cahill's declaration. I read Gabrielle Cahill's declaration, Deanna Cahill's declaration, the teacher of Neil Cahill, and everything that's been filed. I just highlight those. So I took notes on those, and also the police report and the like, or the CAD log, if you will. So Ms. Jackson, this is your motion. Before we get started with that, any preliminary issues we need to address from either party?
I don't think so, sir.
Okay. All right. I'll hear from you, Ms. Jackson. Go ahead, please.
I just felt that this was a serious matter that should be heard before the court. When we came before the court for review in June, I had filed a declaration right after the incident happened with Elizabeth at Winco between her and Mr. Cahill. At that point, Judge Nelson, I think Commissioner Nelson, put in a note like a temporary, he was to have no contact, suspended visitation. We then continued out, went to the next court hearing, and then that judge said that I needed to file motions by the 10th of July. So these were the motions that I thought would correspond with the things that I was asking for. So I just put those things before the court today, sir.
And just to clarify, the suspended visitation that Commissioner Nelson put in place, that was just as to Elizabeth, correct?
Yes, sir.
Okay. All right. Thank you. All right. So I've read over your pleadings that you filed. Do you have any additional information that you want to share or elucidate?
I don't think so, sir.
Okay. We'll hear from Ms. Gilmore.
Your Honor, Megan Gilmore on behalf of the petitioner and non-moving party, namely Kevin Cahill. This matter is before the court on mother's motion for an immediate restraining order. Looking to the recent history of this case, the court transferred custody of both children in January of 2023. At that point, Neil was transferred to my client and Elizabeth was transferred to mother. Neil was transferred based on the ongoing conflict in mother's home. The court has some knowledge, if you do recall, this matter was before you juvenile court in late 2022, 2023. This court set up a review in June to confirm that the children were attending school and had at least a C grade average. After review, mother presented an allegation of abuse in my client's home. Based on this information, Commissioner Nelson, without a motion to esponte, suspended visitation with Elizabeth, maintained visitation with Neil, and then set a subsequent review so that my client had the ability to respond. We were then set before Judge Scudder on July 5th. Judge Scudder indicated to mother that she needed to bring a motion before the court relating to visitation with Elizabeth. However, there was no discussion relating to suspending visitation with Neil. The court did enter a bench order memorializing Commissioner Nelson's order, as my client procedurally didn't have the ability to do a revision based on the fact that Commissioner Nelson failed to enter an order. So at this point, The court maintained, again, my client is a primary parent of Neil and set this matter in front of Judge Bassett. We were frankly blindsided when mother brought a motion for an immediate restraining order with no notice of ex parte intervention. And frankly, what we believe is contrary to the direction of the court just simply the Wednesday before. There was no discussion regarding issues with Neil or a transfer of custody or any sort of indication beyond the fact that she was asking for a motion to modify the temporary order, that she would be seeking a restraining order. As explained in my client's declaration and clear from the record, mother has brought two separate immediate restraining orders, one in July of 2022 and one in October of 2022 that were both denied. We believe that mother abuses the restraining order process, just frankly getting ex parte orders, transfer of custodies, which frankly causes absolute chaos for the children. My client adamantly denies ever being abusive to either child, and my client submits records from the police department indicating that there was no charges recommended by law enforcement, and law enforcement did not think that any of his behaviors were inappropriate. As confirmed by the party's adult daughter, there is severe alienation and manipulation on the part of mother, and we believe that that is really the basis of the problems with Elizabeth and visitation with my client. The child in this case alleges and provides personal knowledge that while she was residing at mother's home, a mother used substances with the minor children, as well as allowed her husband to take the children while in the restroom. We believe the new allegation is preemptive on part of mother by the simple fact that she knew we were before the court in June. She knew that Elizabeth had been failing school. And so we believe that she's taking this preemptive action to basically mask the fact that she's failed to comply with the court's ruling that Elizabeth needed to be going to school and Elizabeth needed to be doing well in school. Moreover, if you look to the underlying motion for immediate restraining order, mother presents nothing to support a transfer of custody or frankly, even an immediate restraining order as it relates to Neil. To the contrary, Neil has been thriving in my client's care. There's been no law enforcement activity, no subsequent charges. We provided information that he graduated from the WISE program. We provided information under seal that the chief teacher has glowing recommendations. I spoke with his probation officer, Matthew, this morning. He's willing to provide recommendations to the court that the child's doing well in my client's care and that he's been in compliance with probation with no concerns. Neil shouldn't have frankly been ripped out of my client's care with frankly no notice to my client and no ability to have this matter heard. This is just further putting this child in severe conflict. And frankly, he was finally getting settled since the January 2023 order. And again, chaos is then entered again 7 months later. So we do believe there's nothing to support the change. We asked the court to maintain the temporary parenting plan that was entered in January 3rd, 2023. We asked the court to consider fees given the procedural fact that we were simply before the court. The court was very clear that Neil would remain with my client. Visitation was suspended with Elizabeth, and we simply need to be before the court on a motion for modification of a temporary orders. At this point, these children have been a part of litigation for 12 years. It's very unfortunate, and it's very unfortunate there is such severe conflict that still continues between these parties. I think, and frankly, in this case, and I know that it's rare in Cowlitz County, but we may have reached the point where it's appropriate to be appointing attorneys for these children under RCW 2609-110. So I do ask the court maintain the temporary parenting plan, consider fees, and frankly consider either appointing an attorney for these children or potentially we need a guardian ad in this case before the court makes any further modifications to the parenting plan, just because these children have been through a lot.
Thank you. Ms. Gilmore, just one quick question that I just need a quick answer to related to the suspension of visitation that Judge or Commissioner Nelson implemented in mid to late June. That was related only to Elizabeth, not Neil, correct?
Yes.
Okay, great. Thank you for that. I appreciate that. Okay, Ms. Counts, anything in response?
Yes, Your Honor. So as far as their accusations, I do feel like I had grounds to bring this order before the court. There's clearly a disconnect between Elizabeth and Mr. Cahill. And if this is the behavior that Mr. Cahill is displaying in a public setting, it worries me what he is doing behind closed doors in a setting where there is no supervision or people. She does not have the ability to contact anybody outside of Mr. Cahill's house while at Mr. Cahill's house. It took Elizabeth almost 30 minutes to open up and tell me what had happened. There was declarations provided by witnesses to this event. This was not the way that somebody should be treating their children. As far as Neil goes, if you treat one child this way, who's to say that you're not treating both children this way? And Neil is just not speaking out about it. I do feel like a parenting class and some anger management would benefit Mr. Cahill. As far as the what she had said about Neil graduating from the services for counseling. Neil didn't graduate from services for counseling. Neil's 13 years old. In the state of Washington, you can choose to not do counseling anymore. At that point, they can't retain you as a client, and they simply dismiss you or graduate you. That doesn't mean that Neil met any of the criteria or outline that they had set for him. It just means that Neil chose to not participate in that program anymore. As far as the grades that Elizabeth obtained, Elizabeth maintained a C average while living with me after all of the traumatic events that she's been through since October of last year. She is currently in counseling. She has an appointment next Tuesday. She is trying to work through those issues. This was traumatic for her. I do feel like Mr. Cahill's actions were not of average actions. They're not the way a normal parent would parent their children. I did bring a motion and ask for a guardian ad litem for the kids. I don't know if that is the same thing that Ms. Gilmore is recommending for an attorney for the children. I certainly didn't do any of this with any kind of malice. I thought that I was following the direct instructions of the judge that we had seen previously. I am self-represented, so I don't have all of the knowledge of the law like she does. I am just doing the best that I can, Your Honor.
Okay, thank you. All right, so the June 11th incident is kind of the precipitating one. Well, this case has a long history, but this is the most recent precipitating event. The indication were that there was maybe some unkind words spoken by Elizabeth towards Mr. Cahill's girlfriend or partner. Some of the worst words you can share about a fellow human, specifically a female. And I don't think Mr. Cahill took kindly to that and kind of let her have it. And it sounds like there's two accounts, at least 2 or 3 individuals who were made aware of what was happening. They indicated that there was loud yelling and screaming and also physical contact of Mr. Cahill's hand to Elizabeth's face. The police got involved. They indicated that there was no evidence of a criminal act and that there were marks of a transient nature, and they chalked it up to parental discipline. So there's a clear difference between a charge meeting a criminal level of charging and inappropriate parenting that rises to a pretty high concern. So I think it's interesting because you looked at the CAD log, the officer indicated that he confirmed that what the observer said or saw in Winco, that the male said he would beat her and slapped her hard across the face. Another witness indicated, and this was confirmed with the law enforcement officer, that hit her twice in the face. So it's concerning, especially when we're talking about a 16-year-old person. I get where dad's coming from. That's if those words were said, highly offensive and inappropriate and wrong. And yet his response with physically slapping his daughter is inappropriate and wrong also. So as to Neil seems to be doing okay, seems to be hanging in there with classes and his probation and the like. Gabrielle's declaration, I take that with a huge, well, I'm just going to say a grain of salt, but maybe a shaker of salt. It's really, I think when I was reading that, there was a lot of reasons for her to make certain statements, and then Deanna Cahill's declaration pointed out a few gaping holes in Ms. Gabrielle's declaration. Teacher of Neil says that he's improved in school, that there's there's been some blips on the radar, but overall there haven't been any behavior concerns at the end of the school year. So he's having better impulse control, notwithstanding in March he had some issues and before that too. So the current parenting plan from January indicates that Mr. Cahill is the custodian of Neil with visitation to mom's house on alternating weekends, Friday 5 to Sunday at 6, and that Ms. Jackson is the custodian of Elizabeth with visitation on the same weekends when Neil's visiting, so the two of them can be together. So at this point, I think the maintenance of that current parenting plan is appropriate. Neil will continue to stay with the father in a custodial position with the same visitation structure. Elizabeth, she's going to stay with mother. There's not going to be any visitation with the father unless Elizabeth requests it. Because of that, I am going to appoint an attorney to Elizabeth under that statute that Ms. Gilmore mentioned, which is a little bit different than a guardian ad litem. The attorney will be a direct representative of Elizabeth and can come to court and speak on behalf. And I'm just going to look at that statute one more time. It says the court may appoint an attorney to represent the interests of a minor or dependent child with respect to a parenting plan in a dissolution action. And the court shall enter an order for costs, fees, and disbursements in favor of the child's attorney. So I think what I'm going to do, I'm going to appoint an attorney. I'm not sure exactly who that attorney is. We'll need to find one, and then it'll be up to 10 hours. So it'll be about $2,500 will be the max. And so if the parents are indigent, then those costs would be borne by the state. If the parties are not, then it says the court shall make an order against one or both parents for the cost and the fees and disbursements. So with that being said, I'm not exactly sure what the parties' financial positions are. I think at this point, I'll make it county pay and that we can revisit it if necessary. So I'll get that order out to the parties, and so you can see that, and we'll get that attorney appointed. So long way around saying that the parenting plan remains the same, with the only proviso that Elizabeth will stay with mother basically full time unless she wants to have visitation and she specifically requests it. So with that being said, I will draft up do a handwritten order for today's motion that memorializes all of that, and then we'll get that filed and the parties can take a look at that. Ms. Gilmore or Ms. Jackson, do you have any questions?
No, sir.
No, so I don't need to prepare any orders. You're just maintaining a temporary parenting plan with her basically as agreed visitation with father determined by child.
Yes.
Okay.
And then that order will also, either that order or a separate order will appoint attorney for Elizabeth. Okay, great.
Your Honor, I have a question.
Who's speaking?
This is
Kevin Cahill.
Kevin, we can talk. We'll talk off the record.
All right.
Okay. All right, that'll conclude that matter for today. And thank you. And I'll see if Ms. Winkles is present. Oh, actually, she's pro se, and then Ms. Winkle is representing the daughter. There we go. Got that.
Sorry, I was confused. I wasn't sure what was happening.
Yeah. And so it looks like Ms. Counts is here, Ms. Gilmore's here. So we're here on Ms. Cahill's motion for contempt related to child support. And I was just looking for proof of service in the file of the documents. So Ms. Counts, did you serve copies of the motion and related documents to Mr. Counts on your motion?
It's Miss Jackson and it's Mr. Cahill, so opposite, but I have served them directly to Miss Gilmore's office. Yes, sir.
Okay, great, thank you. And then Ms. Gilmore, did you receive that information?
So I received unsigned Word version of the motion on August 8th. I then received the signed order to show cause on August 17th by email. I'm willing to accept service and we don't need to do personal service, but it does need to be set over. I was hoping to get a response so we could move forward today, but we are waiting for some information from the bank. I do expect to have a declaration filed either this evening or tomorrow morning. So I don't think their set over needs to be substantial. I know that there is some unavailability due to judicial conference week, but I could set it over 1 week or 2.
Thank you. Ms. Jackson?
I actually will be out of town next week, so I would ask if we're going to set over that we could move to the week after.
Okay, today being the 29th, the 5th, Ms. Jackson's not available. The 12th would be your preference?
Yes, sir.
Okay, Ms. Gilmore, how does that look for you?
That's fine. I'm on the Wahkiakum docket as well, but also on your docket. So I'll just have to balance both, but
Okay.
that will work.
Okay, great. Thanks for that flexibility. So we'll note that the record will reflect that there's the service is good, and then we'll just set it over to the 12th of September at 9 a.m. to hear the motion and hear Mr. Counsel's input. All right, that order is signed.
Thank you.
All right, we'll move to the next matter. Let's move to the Kevin Cahill and Sarah Jackson matter. This is cause 11-3764-7. Ms. Gilmore is representing Kevin Cahill, and Ms. Gilmore is present. I don't see Mr. Cahill unless he's on the phone number.
Yes, my client's traveling today, so I believe he is at 430-6766.
Okay, so that's Mr. Cahill joining us on that phone number. Okay, great. And then we have Ms. Jackson is here. I see that she's present. And Ms. Jackson, can you hear me okay?
Yes, sir.
Okay, very good. We're on today for a variety of items. Well, actually, I take that.
Oh, Your Honor, Aaron Winkle's appearing for the child as well.
Perfect. Thank you. I had you noted up there, but you're off to the far right of my screen. So thank you for that reminder. So it looks like we're on today for a motion related to contempt in relation to some child support. So I've read those pleadings as the moving party. We'll hear from Ms. Jackson first.
I just brought the motion as Mr. Cahill had failed to pay any support for over 6 months. Still currently behind on his September support. It has not been paid as of the filing or today. I'm not sure what other evidence I could provide the court other than he's not consistently paying. He's never made a single payment on time. I had to bring it to court to even really get the issue fully handled. And then it's not even fully handled at this point.
Have you had any address changes in the recent past?
I have not. We have had the same address for over 10 years, sir.
Okay. All right. Thank you. Ms. Gilmore.
Thank you. Megan Gilmore on behalf of the petitioner and non-moving party, namely Kevin Cahill. Following, as explained within my client's declaration, following entry of the child support order, my client was under the impression that he was going to start being garnished by DCS. After a several month period when an account hadn't been created, my client contacted me. We confirmed that it was in fact supposed to be direct from my client to mother. He then wrote that check that we provided under seal on May 8th for $1,428 for February to May. He sent a second check for the $357 in June of 2023. Shortly thereafter, that's when we received the first return mailing for that smaller amount. As indicated within my email correspondence, I then contacted mother, got the updated address. I think it was a PO box issue. Frankly, I honestly don't understand the address issue as well. And my client again paid the amount. We were then under the impression that support had been resolved until I received the correspondence from the end of July, I believe July 27th. I also provided that email correspondence within our responsive materials. I responded back to that email with copies of the check, just simply saying my clients attempted to pay several times. Here are the pictures. My client then became concerned with what was actually going on, because after I sent that email in response with the actual pictures, that same day, the smaller checks were deposited. However, the $1,400 check wasn't deposited. When mother indicated at that point, after several weeks, that she still hadn't received a larger check for the February to May, my client worked with, I believe, Fiber Federal to void the check and then was going to pay. We also provide email correspondence prior to the motion being filed saying hey, we're working in the next couple of days to get the check voided and we'll get you paid. There was some delay with Fiber Federal getting it voided for whatever reason. But prior to bringing this before the court, prior to even filing a response of pleadings, my client was paid in full. And I do really just think that there's no contempt here. The court's aware it must be a willful intentional violation of the court order. My client's paid me particularly to try to coordinate this issue. He sent several checks via mail. This case, for whatever reason it may be, these parties don't need to be dealing with each other. And I simply think that we need to just move forward with DCS enforcement. We explained that my client has attempted to do that. However, because the order filed by or signed by Commissioner Nelson included the cover sheet, DCS isn't willing to enforce. So I did present the court with an updated order that's identical to the order that was previously filed. It just provides DCS enforcement, and that does have my client's signature. So moving forward, I simply don't think there's a willful intentional violation of the court order. It's my understanding that my client was paid up at the time that we provided a response of pleadings. I don't believe there's contempt here, and we do ask to just avoid any further issues down the line that we just have DCS enforcement, so there's no problem with mailing and voiding checks and being returned.
Thank you, Ms. Gilmore. You mentioned just the address issue just a bit. There was a post office box and then there was another address. Do you know where those came from?
My understanding was the court pleadings, but I don't know. There was a mistake to the first underlying address, and then we were provided the PO box, which was correct, and she did receive them. So I just simply don't understand why she never received the 1400, and it's never been returned to my client.
Okay. And then the monies were coming, it looks like they were written off of a kind of a corporate or a company account, correct?
Yes.
And then what's the position of your client in that company?
He's owner.
Okay. And can you give me just a rough estimate number of employees? I don't know if it's a big company, small company.
I literally have zero idea.
Okay. All right. Fair enough. And is it, okay, let me just take a quick look. I just want to look at those checks again. Just give me 1 second. Okay, so there was, before I go to the checks, there was that Kalama address at Lake Avenue. That's the one. And Ms. Jackson, do you know anything about that address?
I don't know that address. I've never been associated with that address. It's never an address that I provided. Even when Ms. Gilmore first initially came onto the case, they had reached out to me and asked for an address. I provided them my PO box. We don't receive mail at our physical address. We never have. So I've never provided any other address other than my physical address for if they needed to serve me with paperwork, and my mailing address, which is my PO box.
Okay. And so at this point, Ms. Jackson, the the $1,428 check that was resent the end of August, that's been cashed. Is that accurate?
Yes, sir.
So your position is that at this point, Mr. Cahill is current, but he wasn't current from February until end of August.
He is not current. His September support was due on September 5th, and it has yet to be paid either. He also, if you look at the mailing date on those checks, on the envelopes provided, Mr. Cahill claims that he knew nothing about this May check not being received by me, yet the June check was sent to an address that didn't exist and was returned to him. In my June 13th declaration, I clearly stated that I had yet to receive any support since the order was entered. He then did not even bother to resend the June payment that was returned to him until late July, when he then sent a late July payment. I did contact Fiber Federal Credit Union just to find out what their cancellation policy was for checks. This could have all been handled in one single afternoon. He would have just made a call to the bank.
Well, I object. That's not provided with any materials, and that's not what my clients testified to. I don't think that was included within our reply materials.
I do remember information about that this issue with the reissuance of check could be taken care of in a short period of time. So I do remember that. So I'll allow Ms. Jackson to continue.
And so my contention is he then waited an entire another month before reissuing a payment. I did not receive that payment until after our last court date, at which point that was set over again. And so as of our last court date, he was still outstanding on the past due child support, as well as his August payment as well. So he did not bother to pay his August payment until the end of August as well. It is very intentional that he is withholding payment until he is brought before the court. He then delayed to pay several times over, was mailed back a check and waited to reissue that check for an entire another month. So I'm not sure how else you're not in contempt of court when you're willfully holding on to checks for months at a time. He also failed to make any form of payment for over 4 months and admits that in his declaration. Like, this order was an order entered by his attorney. So his not reading a court order doesn't negate the fact that he still failed to provide that support for over 4 months.
Thank you. Any response, Ms. Gilmore?
We provide a timeline. I just simply don't, I don't think it bores or holds water that my client would be sending checks to bad addresses simply to avoid support. I mean, he's made multiple attempts. I've made multiple attempts to pay. And we were, even prior to filing this motion, I was simply just asking us, give us a little bit more time and we'll provide it. My client was responding timely. I was responding timely. My client had an intention of paying support. It's undenied that he paid the $1,400 in May. So I don't think there's a willful intentional violation here. And I think that moving forward, it would all be resolved if there was DCS enforcement.
Thank you. Ms. Gilmore, what is your client's position related to the fact that the order requires payments to be received by the 5th of each month, and that did not happen?
I would say if anything, it's a mailing issue, but I don't have a specific response to that beyond my clients attempting to timely pay.
How could it possibly be a mailing issue when none of the checks were written on or before the 5th of the month? The first check was even written on the 8th of the month, which is still after the due date. None of the checks were written on or before the 5th of the month.
All right, so here the motion is a motion brought by Ms. Jackson for finding of contempt for a willful and intentional violation of a court order, which is specifically the child support order that was entered back on February 8th of this year. That requires $357 of support payments to be received by the 5th of each month and starting on February. So the allegations are that there is this issues, that related to the check, the May 8th check, the one that apparently was mailed out and got messed up, and how it got messed up, I'm not exactly sure. So there's some extraneous address being used, and was that may have been part and parcel of it. The thing that's interesting to me is that Mr. Cahill indicates that he thought the Division of Child Support would be taking the money after the February order. But what we see is that in February, there was no payment. March, there was no payment. April, there was no payment. And May to May 5th, there was no payment. It seems that when there's a court order, people will generally make sure that they're compliant with that court order, which would mean that you would check your bank account. Did my child support go out this month? Did Division of Child Support take the money that I thought they were going to take, to make sure that you're compliant with that order? I think that's a reasonable standard, that a reasonable person would know that money is not being debited from their account, that there's maybe excess funds in there that it should not be, because there's an expectation that DC Division of Child Support would be taking them. So it doesn't seem reasonable to me that Mr. Cahill was oblivious to that. If he's the owner of the company, then I recognize owners of, I'm making an assumption, I don't know this, Ms. Gilmore wasn't exactly sure as far as the size of the company, but if it's a smaller size company, which it's a welding and fabrication company in Kelso, Washington, that if it's a smaller company, then recognizing owners of business are really busy. And number two, recognizing that if you're owner of business, then you have control over books and finances. So that's kind of my take on that, is that it's unreasonable for him not to have known that. The issue also is timeliness of the payments. They're due on the 5th of each month. And with that extraneous address being used, the Lake Avenue and Kalam address, which kind of came out of nowhere, and I'm not exactly sure how that happened, but it did. I think that's a showing of willful and intentional violation of the court order, that it's not timely, and that I'm happy to hear that the payments are current up to at least the August payment, which was also late. And then Ms. Jackson raises the concern about not being timely for September. So with that being the case, I'll make a finding of contempt that there is a willful and intentional late payments for several months earlier this year. I'll impose a $500 civil penalty that needs to be paid within 30 days. Otherwise, it will accrue at 12% interest. I am amending the child support order. I think it's just that one box, correct, Ms. Gilmore, that allows Division of Child Support to collect that child support.
Yes, and do you have a copy of that before you?
Yeah, I remember looking at it, and let me just make sure I have it here. Maybe it was just did you file it? Maybe that's where I saw it.
You should have received a bench copy as well, but if not, then I can circulate her signature and enter it ex parte, whatever the court would prefer.
I think I have it here. Let me double check. Ms. Jackson, did you receive a copy of that proposed amended child support order?
Yes, sir.
Do you have any concerns about it?
Just that it only addresses the issue of the direct payment. It doesn't address any of the other issues, such as the change in custody of Elizabeth, the fact Mr. Cahill has access to money that he is unreported to the court. Like, I feel like if there's going to be an amendment made, that it needs to be properly made, not just one thing addressed.
Okay. All right. So I think some of the issues that led up to this finding of contempt may be ameliorated or reduced by virtue of the direct debit from the Division of Child Support, which this amended order takes care of. So on that basis, I will sign off on that amended order that at least corrects that issue or makes that issue more clear, recognizing that there are other issues, but sometimes it's a piecemeal approach. So I've signed off on that. Any other issues or any other clarification needed?
Is Division of Child Support going to handle the September support, or are you giving Mr. Cahill a date at which he should provide that payment? Because I imagine that it will come back in 2 weeks for presentation, which point he'll be an additional 2 weeks behind and almost an entire another month.
I've already signed the order, so it's going to be entered today, so we don't have to come back for presentation.
Okay.
Your Honor, if I might, this is Erin Winkles on behalf of the child. If somebody could make sure that the child contacts me, I'd appreciate that. I am having trouble getting a hold of the child, and I do need to speak to her in my office.
I actually did provide her direct phone number to your office, and she called twice and was told she would get a return call and was never returned.
We have attempted to call her multiple times, including this morning and yesterday. If she can give us a call, it's going straight to voicemail, and her voicemail's full.
Okay. She is at school, but I will send her a message to call as soon as she's out.
So the question raised by, thank you, Ms. Winkles, I appreciate that. The payment method on this amended order of child support talks about the registry and the enforcement through garnishment if needs be. And Ms. Gilmore, as far as the effective date of this, I'm not sure how long it takes for them to set that up, because sometimes they will do like a test run and then do all that.
Typically it takes, what I've noticed post-COVID is like 6 to 8 weeks to set up the account. What I typically advise my clients to do is continue to pay directly until enforced, and then we provide receipts to DCS. That's what I typically advise my clients to do.
Okay. So Ms. Cahill, I don't have an exact answer as far as when DC or the Division of Child Support will begin collecting those funds directly, but from what Ms. Gilmore's experience, it sounds like 6 to 8 weeks. So there'll still be an obligation of Mr. Cahill to timely pay until that direct debit occurs.
And then is there any action that can be taken on his current outstanding civil penalties that he's never paid? That was part of my filing as well.
It was, and as far as options, parties can bring motions to enforce a judgment or reduce something to a judgment. That's one option. The other option is to work through council, come to some type of an agreement and file that. That's a different option also. So I can't give you a direct legal advice, but I can provide some options.
Okay, thank you.
And then just last question to the parties. There was also presented a child support worksheet. I'm inclined not to sign off on that since we're just amending that order. So I'm just going to sign off on the amended child support order.
I think that the reason why, and I don't know if it's necessary for DCX, but the order, I don't know what order Commissioner Nelson did, but if the court looks at Odyssey, the clerk's office makes a note that there's no worksheets provided. So I guess my only concern would be is the proportional share. Yeah, the February 8th, 2023 filing indicates no worksheets. So I believe that they're consistent, but I would defer to the court if you don't want to enter them.
Ms. Jackson, did you receive a copy of the worksheet?
I don't recall receiving the worksheets, just the order, Your Honor.
It shows a proportional share of income with Mr. Cahill at 67.6% and Ms. Jackson at 32.4%, with Mr. Cahill at a net income of $59.21 per month and Ms. Jackson at $28.32 per month. Do those numbers sound accurate?
Yes, sir.
Okay. And then it goes on the back section of that support worksheet. It's an attachment related to the residential split adjustment that allows for the with Neil and Elizabeth kind of being split out, that reduces the normal child support amount down to $356.58. So just want to make sure you're aware of that additional attachment to it.
Yes, sir. Thank you.
Any concerns if I were to sign off on that, which would allow DC or which would establish kind of that proportional income share?
No, sir.
Okay. All right, I'll sign off on that. All right, let me check with Ms. Gilmore if you have any additional items.
I don't believe so, Your Honor.
Okay, Ms. Jackson, any additional items?
No, Your Honor.
Okay, that'll conclude today's hearing. Thank you.
Thank you.
Kevin Cahill and Sarah Counts is cause 11-3764-7. Ms. Gilmore is present representing Kevin Cahill. Ms. Winkles represents the minor child Elizabeth Cahill, and Ms. Sarah Counts represents herself. Ms. Counts, are you on the line today?
Yes, sir.
Okay, welcome. And I apologize, Ms. Jackson. Thank you for your name, and that's easy for me to remember. And then Ms. Winkles, are you on the line?
I am. I won't be able to turn on my video. I have 2 8-year-olds who are off school today. If as long as you don't mind the video being turned off during this, that would be okay. Unless you can give me 2 minutes and then I can go wrestle them into the other room.
I have no concerns with that. Ms. Gilmore, any concerns? No. Okay.
No, I'm happy to wait. Or
Ms. Jackson, are you okay with Ms. Winkles keeps her camera off?
No, I have no objections to that.
Okay, great. Thank you. All right, this is a motion brought by Ms. Winkles related to the child on the phone. Ms. Winkles?
Yes, Your Honor. I've been asked to represent the child through court appointment, which would be all well and good, except I have never been able to get a hold of her when I'm trying to get a hold of her. It appears that she did have a phone, that mom took the phone, and understanding that obviously child did quite a lot to deserve the phone to be gone. However, I can't communicate with her. So I've spoken to her once for a period of about 15 minutes. I've never been able to get a hold of her again. It seems to be a miscommunication, or not sure why, but none of my calls are returned, or my office will leave a message. We will get a call back after business hours. or before business hours. So my hours, which are posted on the outside of my building, also posted online, are 8:30 till noon. And then from 1 to 5, Monday through Thursday. On Friday, we close at 3:30. Those are posted everywhere. It appears that the only time I'm called back is either before we start work, during the lunch hour, or after work. All I want to do is be able to speak to my client. I wasn't even able to speak to her about this motion. I did tell her I was going to file it. I've never been able to get her to sign anything because I can't communicate with her. So if mom doesn't want to let her have the phone because she's been punished, then I asked for, during the pendency of litigation, that client be brought to my office at least once every 2 weeks for half an hour communication with her. It's very difficult when the only time I have been able to speak to her, it's been on mother's phone. And so that kind of concerns me, that we're using, this child is not against mother, not against father, but the fact that she was appointed counsel says something. And she is close to the age of majority. So I do ask that we find a way for me to communicate with her alone, to where she's not using anything that is belongs to another, that can be monitored, that she's not only able to communicate when a parent says, you know what, she likes me right now, so I'm going to let her communicate, or anything of that nature, but it's actually the child gets to say what she really feels. And that can only happen with the utmost respect for that child's privacy. So I put this motion in asking for her phone, but I know that that's kind of going against, obviously, what the parent is able to do with behavioral modification. So I ask that Your Honor maybe come up with a way to where I can speak to her at least every 2 weeks. If something comes up that's very important, I'd ask that she be allowed to call me maybe from school, but in any event, needs something so I can communicate. Otherwise, I can't really do anything for her.
Thank you. Ms. Gilmore.
Yes, I represent petitioner Kevin Cahill. We do not have any objection to the motion. I already signed the proposed order presented by Ms. Winkles. I think it's just important to note for the record, I didn't provide any responsive pleadings because, again, we agree. But it's important to note the fact that my client hasn't had any contact with the child, so he hasn't participated in restraining the child's ability to have communication with Ms. Winkles. So I did want to make that note for the record, and just generally the fact that this just chaos going on in mother's home is frankly the reason that we requested this attorney. So my client has concerns about, frankly, both pleadings presented by Ms. Winkles as well as Ms. Jackson. So we do ask the court grant the motion, provide the relief to ensure that this child has some sort of representation, again, because the declaration is relatively concerning. This child is failing out of school and the like, and it needs to be addressed.
Thank you. Ms. Jackson.
I actually have a couple of questions, if I can ask Miss Winkles or even the court directly. I am just wondering, is Miss Winkles the same Erin Winkles that was previously associated with Wallstead Merching?
So that's good. Can you just focus on the motion at this point in time and just tell me your position?
Yeah, I kind of am. I am a little concerned that if she is the same Erin Winkles, she actually represented Mr. Cahill in this matter when he was represented by Wallstead Merching. She appeared in court for him several times, so I have a little bit of concern about that and how she's then viewing me. So I guess that's my reason for that question. As far as Elizabeth's grades, Elizabeth is currently passing all of her classes. She had her phone returned to her almost 2 weeks ago because she had made changes to her grades and her behavior. The phone was returned to her. I also provided Miss Winkle's office with our home phone number, which is also a way for her to contact Elizabeth on the 16th of October. They've not reached out to that phone number at all. Elizabeth is home alone every day after school, 4 days a week. She's only has somebody home every other Tuesday and every other Thursday with her, so she could be reached that way as well. There's been no attempt to even make contact with her at either of those numbers in the last 2 weeks. So I guess those are my concerns. Also, she says that she only spoke with Elizabeth for 15 minutes, but I show a conversation that she had with Elizabeth for 1 hour and 4 minutes and 52 seconds on September 22nd, which was the date of her appointment. So I'm unsure how she only spoke with Elizabeth, but there was over an hour conversation had.
Thank you. And one quick question for you, Ms. Jackson. As far as in your pleading, you indicated that, you have particular appointments, lashes, whatever, add that making an additional appointment with Ms. Winkles for your daughter wouldn't be an issue. Did I interpret your pleading correctly?
I never had an issue. Actually, I was the one that reached out to Miss Winkle's office on August 9th when I received paperwork saying she was the one appointed to Elizabeth. I asked if an appointment needed to be scheduled. Her assistant told me no, she was on vacation or something at that time. I did ask that if appointments need scheduled, if they could please just call me because Elizabeth does not drive yet, and that I'd be more than willing to make an appointment and bring her there. Nobody called me to schedule any appointments at our last court hearing.
I think you answered my question. Thank you. I appreciate that. So my impression was correct. Thank you. All right, Ms. Winkles?
Yes, I have never represented Mr. Cahill. It is possible that under Walstead Merching that he was represented by Nicole Tideman or by Chelsea Baldwin, and maybe I came on to set over a hearing. I have no facts of this case whatsoever. He was not one of my clients. He may have been Walstead Merchings. I predominantly did real estate there and construction law. With regards to callbacks, I personally have made callbacks. The appointment may have been longer than 15 minutes. I couldn't remember, to be honest. It was so long ago. It is concerning that mother knows exactly the time, and this is part of the issue. Mother knows exactly the time that I spoke to the child. This is supposed to be something that's completely between me and the child and has nothing to do with the parents, Mr. Cahill or mom. And again, my client is obviously happier where she's at. Well, according to our last conversation, is happier where she's at now than she was in the past. There are issues, but I'm not on either side of the parent. I'm on the child's side. It still remains the same. The fact that the child's had the phone for the last 2 weeks is a little concerning that she hasn't called me. And if child doesn't want to be represented, I need to know that as well. It's completely up to the child. I still ask for the same thing. I think even bringing her in some point next week for half an hour talk, if child doesn't want representation, if child's happy now, great. These are teenagers, so they vacillate. But still, I do need to speak to her. I can't represent somebody that I don't know what they want.
Okay, great. Thank you. Well, let's do this. Let's just make it 2 times per month that Ms. Winkles has opportunity to meet with her client. I'll ask if Ms. Jackson, if you could reach out to Ms. Winkles and set up an appointment in the next week or so, and then they could meet. And if there's need for continuing representation, great. Then we'll be meeting for 2 times per month.
Yes, sir, that's fine.
Okay, great. All right. As far as an order to that effect, I'll do I have an order for relief submitted by Ms. Winkles. Okay, I'm going to say the child Elizabeth Cahill shall have 2 appointments per month with her attorney in person. All right, I've signed that, and I'll take care of the hearing today. Thank you.
All right. Thank you, Your Honor.
Thank you.
Number 1 on the docket, Cahill v. Cahill. Cause number 11-3-00764-7. This is a request by Ms. Winkles to withdraw. We have Ms. Gilmore. Anyone else other than Ms. Winkles on this matter? Hearing none. So the request has been made. Ms. Gilmore, I don't know if you had anything you wanted to say. You're muted, or I don't have sound from you.
To the best of my knowledge, Your Honor, she was in agreement. She has no objection.
Okay, thumbs up from Ms. Gilmore. So with that, hearing no objection, or seeing no objection, I should say, I will go ahead and grant your withdrawal.
Thank you, Your Honor. And I'm not sure another attorney needs to be appointed at this time. It seems that that everybody is in agreement. My client seems to be in a good place.
Okay. Okay. All right, that matter is done.
Thank you, Your Honor.
Next, I have Kevin Cahill and Sarah Counts. 113764-7 is the cause number. Ms. Gilmore is present. She represents Kevin Cahill. And Ms. Jackson, I think you're representing yourself, correct?
Yes, sir.
Okay, and she's present. And then Ms. Jocelyn is here representing Elizabeth. And Ms. Jocelyn, are you here?
Yes, Your Honor, I'm here.
All right, very good. Great. Let me just pull up my notes and then we'll go ahead and get started. All right, this is Mr. Cahill's motion related to a modification of decision-making as it relates to extracurricular and also just decision-making in general. So I read the input that each party submitted and filed with court. So I'm ready to hear from Ms. Gilmore, and then we'll hear from Ms. Cahill and then Ms. Jocelyn.
Yes, Your Honor. Thank you, Megan Gilmore, for the record on behalf of petitioner Kevin Cahill. This matter is before the court on my client's motion to address decision-making relating to extracurriculars over this summer, as well as broader picture of extracurriculars and decision-making in general. Looking to my motion, there was some correspondence back and forth between the parties in March of this year regarding extracurriculars and my client asking if she would authorize the child to be in rodeo. She indicated back in her response to my client that she needed more information. I subsequently drafted the correspondence attached to her motion from April, outlining the activities for the summer, and we projected what was going to be potentially a conflict for her weekends and asked her to provide the child to those events, or alternatively, we were willing to, or my client was willing to take the child to the event and discuss makeup time. We didn't receive a response, and that's what necessitated this motion. Now, mother indicates within her responsive pleadings that she doesn't agree for a variety of reasons. My client isn't looking to interfere with mother's time, and my client was frankly more than willing, as indicated within our correspondence, as well as the email correspondence, to frankly do whatever was in the best interest of the child and work with mother to ensure that the child could participate in the events, but again, still have visitation with mother. There was some sort of conversation or discussion or argument in her declaration that we were asking for her to forfeit all of her summer visitation. Again, looking back to that correspondence, I do believe that only 2 weekends conflict with her visitation. Again, we simply ask that she participate in the event, support the child. But again, if she's not willing to do so, then my client would be able to take the child to the event, and we could discuss makeup time if that is warranted by the court. My client denies the allegations of behavioral issues by the child. He frankly obviously isn't aware, doesn't have personal knowledge of what happens at his home, or excuse me, mother's home. But I would look to the email correspondence. She's not referencing these alleged behavioral issues within the email correspondence. She mainly is citing, frankly, she just doesn't want to take the child to the events and wants to pressure my client to modify the summer schedule, which at this point he wasn't willing to do. My client explains that he's worked closely with the child provider since we were last before the court. The child has subsequently completed probation, has graduated from the WISE program, and has completed the outpatient mental health with Columbia Wellness. My client, as again indicated within the communication submitted by respondent, my client simply asked that the parties set aside their differences for the best interest of the child, and again asked to just simply work this out because again, it's in the best interest of this child to participate in the extracurriculars. My client explains that this child has been preparing for these events throughout the year, training for this, and I think just in general, extracurriculars are good. They create stability, accountability for the child, and frankly, a schedule in the summer that he will be responsible for complying with. We do ask the court allow the child to participate in these events, again, as it is in his best interest, and my client is more than willing to have facilitate any change to the schedule or provide, step in and provide the child the resources to get to the events during mother's time. We also are asking the courts to make a modification to the temporary parenting plan that was entered in January of 2023. We are asking the court to allow my client to have sole decision-making regarding meal. My client explains, and I think that frankly, it's borne out within the communications that are submitted by respondent. These parties, frankly, have no ability to co-parent, unfortunately. This case has been litigated heavily since 2011. This petition to modify was filed in 2016. Despite my client's best efforts to simply communicate, to coordinate visitation, ensure compliance with the parenting plan, there's simply no movement here. Unfortunately, to ensure compliance, I think that we're going to have to be before the court regarding any decision that needs to be made for the child, if it be football, if it be rodeo, if it be educational decisions, because again, what we see here is my client asking and providing the information. Mother indicates she needs more information. And again, my client citing the fact that we've provided the attachment with the information and we simply just receive no movement here. My client is trying to avoid a contempt motion. He's trying to comply with the court's orders and he's trying to do what's in the best interest of the child. So we are asking the court to grant our motion, allow the child to participate in rodeo over the summer and to modify the parenting plan relating to meal and provide my client sole decision-making just to ensure, at least for extracurriculars, that this child can participate in these activities and not be put in the middle of these people's fighting.
Thank you, Ms. Gilmore. Ms. Jackson?
Oh, sorry, Your Honor. This motion doesn't relate to my client, and I haven't heard anything today that would warrant any input, nor has my client given me any information that would be helpful to the court.
Very good. Thank you, Ms. Jocelyn. Appreciate that. Okay, Ms. Jackson, I'll hear from you, please.
Yeah, I actually have a couple of concerns with what's being presented currently to the court. When we initially had a conversation about spring break is when I initially brought up the summer schedule and what was going on. I do have a stepson who has a parent outside of our household. And so we have to co-parent with that parent as well. I asked at that time back in March what the summer schedule was going to look like. I explained to Mr. Cahill specifically how time off works for my company. And if I wanted to request time off for June, I had to do it a month and a half in advance by the 15th of the month. I explained that. I've explained it multiple times to him as well as his attorney. I can't just change my schedule on a whim because they feel like I should, because they planned an activity for Neil. I understand that Neil wants to participate in these things. I'm not discouraging him from participating in these things. However, I do have to be given reasonable time to make reasonable accommodations. Him sending me emails or having his attorney send me emails a week or two before an event is not a reasonable time. My company that I work for requires a month and a half notice for time. The last time we agreed to make a change over spring break, Mr. Cahill failed to even bring Neil to the agreed change in visitation. So I just missed out on that time with Neil. I should have filed a contempt of court at that time, but I let it go because it was something that Neil wanted to do. So I don't understand at what point I can express that I don't have an issue with him participating as long as I am provided appropriate time to make arrangements. I also would like the other issues addressed, such as his multiple school suspensions, the actions he is taking. They can't say that I...
With your argument, please. I think you were talking about school suspension.
So I do feel like that I do feel like I had brought those things up to him. I had asked what his plan for summer vacation was, if he give me dates. He was unable to provide them. I am a manager in a retail location, so I can't not work every weekend because that's what's convenient. I do try to not work on the weekends when the kids are with us at our home. But it does, like this weekend, I'm scheduled to work on Sunday. It's a holiday. All the fathers in our store are off. So it unfortunately is a weekend where I have the kids and I will have to work part of the day on Sunday. if I want a scheduling accommodation, I do have to give my company reasonable time to make that scheduling accommodation. I was simply asking for those dates back in March. If he could not provide them, I was asking for an alternative. He never even bothered to respond to any of that, and then brings a motion to the court saying that I never responded. I wasn't properly served by his attorney's office. They continue to serve me via email, even though I've asked to not be served via email. I've asked them, they specifically asked when they came on board with him what the best mailing address was for me. I provided that information to them. I do not get mail at our physical address. This was an issue last year with child support. It continues to be an issue as they continue to mail things to my physical address and not my PO box, even though they're fully aware I don't receive mail at our home address. And so saying that I just failed to respond is not true, because one, I wasn't aware of the request, and two, I wasn't allowed proper time to even make the changes. So I don't feel like it's appropriate for Neil to participate in the activities because none of the other issues have been addressed. And I don't feel like I should have to forfeit my time and plans that we have already made for the summer because they failed to communicate in a timely manner.
Can I ask you a question about the address issue? Have you filed a formal change of address notice?
I wasn't aware that the court ever had a different address for me other than my PO box. It is the one that I've always used. So no, I guess I have not, because I wasn't aware that they had a different address for me, sir.
Yeah, just to clear up any confusion in the future, if you could just please file that change of address form, and that'll be officially in the records, and everybody, that'll kind of clear up confusion going forward. Appreciate that.
Yes, sir.
Just want to ask you about the school suspensions. You said there were multiple. What were the timeframes of those?
So there was one in December, one I believe in January, and then another about a month later. The first two were physical altercations with another student, and then the third one was a inappropriate contact with a female student in his shop class. And I do feel like both of those are reasons that he should probably be in counseling.
Do you think those are, I think in your pleadings, you alluded to the fact that would be, because of those suspensions, that would be a reason for not allowing him to do rodeo, because that would be kind of something that he likes, and that would be a counterbalance to that behavior?
I kind of am not a fan of supporting bad behavior, and I do feel like when he's continuing to have these actions and continuing to do things that are not in alignment with normal school standards and multiple suspensions, like, why are we continuing to reward bad behavior? It clearly, trying to engage him in those things is not changing that behavior. So why are we continuing to reward it? And I do feel like it is a reward to him. He gets to go and not have to be at our house and be held accountable for those things. And so it is a reward to him.
All right, thank you. Okay, Ms. Gilmore.
Yeah, just briefly, Your Honor. Again, my client provided notice as soon as it was available, the schedule. The schedule was available in April. We provided it in April. I am confused why she didn't receive the correspondence asking for an agreement to be reached, as I did provide that correspondence to her via her PO box that she's previously requested. I do apologize that my office has no intention of not serving her properly, but again, I think that my staff were relying on the notice of withdrawal that was from 2018. And we have received and provided service continued by email. So I do apologize if she didn't receive anything, but I don't understand why she wouldn't have received the communication from April 25th, as that was provided by PO Box. As you can see from the argument, we simply are just asking for a firm understanding of what her position was. It seemed at the beginning of her argument that she was going to agree, but she simply wanted to come to an agreement about a modification of the parenting plan. Now she's going back to the behavioral issues. I would object to the consideration of the alleged suspensions, I don't believe that that was specifically outlined in her declaration, and my client could have provided a response. All I'm aware is that at least one suspension occurred based on the communications that happened in March. My client explained what he was doing with the providers and what was going on with the suspension. Based on my understanding, thereafter, the child has subsequently completed mental health treatment and completed some of these other programs to remedy some of the behavioral issues that were happening in the winter. So we are asking the court to provide this child the ability to participate in the events. And we are simply asking that my client, as the primary parent of this child who is engaged in all of these services, be allowed to make decision making. I don't see from here that mother has she expresses concerns because she doesn't want to take the child to the rodeo, but I don't see her doing any legwork to be communicating with these providers despite her concerns. I mean, she obviously is an equal parent that needs to be making decisions, but I don't see that she's been doing that based on her alleged concerns. Also, as we're before the court, she has provided the court that she does have problems with her work schedule, but I haven't seen affirmatively that she's unavailable or have something planned for the weekends in question, which are only two. One's in July and one's August. I would also talk about the notice provided. We provided notice in April and the events in July. So I do believe that that corresponds with the work schedule notice. So I simply think that we just have an individual that doesn't want to take the child to rodeo. I don't think it's a behavioral issue. I don't think it's a conflict issue. And again, my client just simply wants to do what's in the best interest of the child.
Okay, thank you. Ms. Jocelyn, did that raise any issues for you, Ms. Jocelyn? No? Okay. Ms. Jackson, you had a question?
Yeah, I just wanted to say that I do believe that I did reference the suspensions. I actually submitted several emails back and forth between Mr. Cahill and I where we talked about the school suspension. So I actually do feel like that information was provided to the court before today. And then I also, there's one other thing that she had said that I'm sorry, I forgot about it now. She says that she says that they provided information to me by April. I have to have my request in by April 15th. So even if she did provide that information to me on April 17th, which is my understanding of, it was either the 17th or the 20th when that email or correspondence was sent to me, it still was after the date that my company requires for any June dates that could be requested off. I did not receive any of that correspondence until Elizabeth told me we were going to court, at which point I went in search of it in my email and found it in a spam folder. So I have only had knowledge of this court hearing and those dates for about 2 weeks now. So still have not been able, I've submitted for the August date off, but I don't have any way to change my June schedule as of right now. And so it's not me not wanting to participate, it's me needing appropriate communication and appropriate time to request that time off. I feel like I'm being punished and having my rights taken away because I have a job that I must go to or request time off in an appropriate manner. And I don't feel like that's a reason to have my decision making taken away. I just need appropriate communication so that I can make the appropriate arrangements.
Okay, thank you.
Your Honor, can I clarify something for the court?
Yeah, go ahead.
I know Ms. Jackson indicated Lizzie told her about the hearing. I just wanted to clarify for the court, the only thing that was communicated to my client was there was a hearing and it was not concerning her, so we would not be discussing it and I wouldn't be disseminating any information to her.
Great. Okay. Thank you, Ms. Jocelyn. Appreciate that. Okay, the motion here is brought by Mr. Cahill to allow Neil to participate in the rodeo events over the summer. Ms. Jackson is concerned about notice and about the difficulties with scheduling time off with her work, that lead time of about 6 weeks and the like. So there was concerns raised about the addresses. I think that's going to be rectified just with that change of address being filed by Ms. Jackson, pardon me. So as far as the rodeo on July 13th and through the 14th and August 24th through the 25th, those are the 2 days that have been identified as conflicting or being on the residential time of Ms. Jackson. I'm going to allow Neil to participate in the rodeo on both of those dates. If Ms. Jackson can take Neil to the rodeo on those dates, then that would be her residential time with Neil over those weekends. If she's not available or not unable, if she's unable to do so or doesn't want to, then Mr. Cahill will be responsible and will have that time with Neil over those 2 weekends. I am granting Ms. Jackson makeup time in the fall of 2024 for those, if one or both of those weekends is that she's not able to use or spend that with Neil, then that makeup time would be in the fall of 2024. So the idea with the in-school suspensions sounds like Neil's worked through a lot of stuff. He's completed his probation, was on WISE, and he's completed his outpatient. So hopefully there's some lessons have been learned there, and that he'll be making some improvements. Oftentimes for young adults, having consequences happen close in time to the behavior that needs to be corrected is really important. When it becomes too attenuated or far away, such as exacting maybe some discipline for behaviors in December, January, February, happening in June or July or August, is a bit attenuated and may not meet the purpose that was hoped for. So I'll just make that comment. So I'm going to allow that the rodeo, Neil, to participate in the rodeo this summer on those 2 particular weekends. As far as sole decision making regarding extracurriculars going forward, the parties have had difficulty. You can feel the strain when reading the declarations between the 2 of them. It's palpable, and there's difficulty there. And yet, I think there's not enough to make that change at this point. So I'm going to hold off on that. The parties will continue to work through some issues, and hopefully they can work through those. But decision making and extracurriculars remains unchanged. So any questions on the court's ruling?
No, I don't.
I actually do. I'm not sure the court is aware of this, but Neil's suspensions actually came a year after he finished counseling. So he was removed from counseling in January of 23.
What's
and
your question?
I'm not sure that the court is aware of that. I just was asking if you're aware that, I know you said in correspondence with.
Nope,
Okay.
not aware of that. Any other questions? Okay. As far as a presentation date memorializing today's ruling, we could look at a presentation of June 21, or I think June 21 or June 28th. Oh, I'm going to be on the 21st yet. June 28th. How does that look for the parties? Thank you. Ms.
That
Gilmore?
works.
Okay.
Your Honor, can I be excused from that hearing?
Yes. Yes.
Thank you.
Yes. And then Ms. Jackson, June 28th, 8:45 in the morning for presentation.
Yes, I am just trying to confer with my work schedule, sir. Just one moment.
Okay. So Ms. Gilmore will be preparing that order. If you agree that she captured what the court ordered here today correctly, you could simply sign off on it and we wouldn't need the hearing on the 28th. If you feel that she doesn't have it correct, then be here on the 28th at 8:45.
Yes, sir.
Okay, great. We'll set it for that date, Ms. Gilmore.
Just briefly, should I have a signature line for Miss Jocelyn? I know that it's a little strange procedurally.
Repeat that question. I missed the first part.
Should I have a signature line for Miss Jocelyn?
Ms. Jocelyn, what do you think?
I don't think it's necessary on this one because it doesn't relate whatsoever. So the disagreement's really going to come from Miss Jackson.
Yeah.
Understood. And then also I would like to, Miss Jackson, I will, hopefully we can coordinate those fall dates so there's just no conflict. I can put generic language that makeup time will be in the fall, but if we can try to coordinate those dates, hopefully we can do that prior to the presentation.
All right, thank you.
Okay, thank you.
3-00764-7 Cahill v. Counts.
That matters, Your Honor.
All right, we have Ms. Gilmore. Just a second here, let me switch my file over. I still show Jennifer Joslin.
She's actually the representative for the child. Lizzie, the other child not subject to this restraining order, but she was served, I believe, with our materials.
Okay. Hold on. Everything's loading very slow today. And I just want to make sure, Sarah Jackson, you are previously known as Sarah Counts, correct?
Yes, ma'am.
Okay. All right, counsel, go ahead.
This is actually her motion.
I apologize. Yes, thank you. Go ahead, Ms. Jackson.
I guess I should just start by letting the court know we were unable to still serve Mr. Cahill officially last week. I did finally give up and just serve him via certified mail. Was mailed out on Friday. We filed that service with the court on Friday afternoon, and he should receive that information. It says the first date of service would be today via certified mail. We did try on Wednesday, Thursday, and Friday several times through the day to get him served, but we're unable to get him fully served, Your Honor.
Ms. Gilmore.
Client doesn't want to cause any further delay. I previously advised Ms. Jackson that my office doesn't typically accept service of this type of petition, but we're prepared to move forward today.
Okay. All right. So with that, with the acceptance of service, we will go ahead and proceed forward. Go ahead, Ms. Jackson.
Yeah, so like I had stated in my initial filing, I was very surprised at Neil showing up at our house at about 1:47 a.m. on the morning, the night of the incident happening. He came in, he was very disheveled. He said that he had ridden his bike from his father's house to our house. He stated that there was a confrontation.
May I voice objection?
Go ahead.
I just simply object to the child hearsay. There's simply no basis or personal knowledge or frankly any evidence supporting this petition, but for these allegations, and I don't think it's appropriate for the court to consider.
So, Ms. Jackson, that's one thing I did see when I reviewed everything is the primary part of what is stated in here is child hearsay. And child hearsay is not admissible. And so
I guess
cannot be
the primary.
considered.
So I guess I don't understand what that is. Could I get some clarification on that?
So there are rules of evidence that talk about what evidence or statements or things like that that can be admitted into the court for court's consideration. And there are rules that talk about what's called hearsay. And you are offering the child's statements for proof of the matter asserted, which is a court rule. It's not allowed. So in other words, you're saying to us what the child said.
Okay.
And that's child hearsay. So anything that the child said can't be considered or argued.
Okay, so I'm not allowed to tell you that he stated that he was choked by his father. I don't understand how I prove that he was choked by his father then.
That's where you would have to consult with an attorney.
Okay,
Can I ask
for an continuance then so that I could try to get an attorney on Neil's behalf? Because I'm not sure how I would prove that without being able to enter in the things that Neil had told me. I'm sorry.
Ms. Gilmore?
I would object to a continuance. We were previously before the court last Monday, where Ms. Jackson failed to appear, alleging she had some sort of medical appointment. My client is the primary parent of this child. School has started or is about to start if it hasn't started already, and it's not appropriate for my client to have ongoing no visitation with zero basis. As noted in my client's declaration, this is the fifth request for a restraining order since this case has been pending. All previous have been denied. The child was doing extremely well in my client's home. So I would object to a continuance, and I think that we do need to move forward today.
So Ms. Jackson, do you have any information beyond what the child said, child's statements?
Well, I have the previous, Mr. Cahill has a domestic violence history himself. He has several convictions for domestic violence. He currently has no contact with our 17-year-old due to the fact that they themselves had a physical altercation. So this doesn't fall outside of a realm of things that have happened previously with other children that I share with Mr. Cahill. So I would say that historically this has happened before. It is not out of the realm of possibility that it did happen indeed this time. I'm sorry that I was indeed scheduled for surgery last week. I did not mean to cause a delay with the court. I'm not meaning to cause any kind of delay with the court now, but I do have to ask for a continuance because in Neil's best interest, I do have to try to do what's best to protect my child. Him continuing to go back to a household where he has the potential, there is a history of abuse, there is a history of Mr. Cahill physically harming and or mentally harming my children. I do have a hesitation for that. I do have a reservation for wanting to send him back there. And I'm not sure what other steps that I could take at this time, as I'm not an attorney. I'm sorry that I don't have the full knowledge. I'm just trying to do the best that I can on my own. So I guess I just need the continuance if I can have one. I'm sorry.
Your Honor, may I respond?
Go ahead.
Regarding the alleged abuse relating to Lizzie, that was contained in a previous protection order that was denied. So she's previously made these type of allegations that were denied before the court. So I think that it's, again, there's zero basis to move forward. And I think if you look to, again, the actual evidence before the court, this child wasn't alleging anything. He frankly was upset that he got in trouble for smoking marijuana, and he prefers to go to his mom's because she doesn't have those rules. And I think that if there was a true safety concern, she wouldn't have dropped him off at my client's house, then facilitated the child walking away from the home while my client was actively trying to help.
The Zoom call dropped off before the end of the hearing, so we don't get to hear directly from the judge. But we can see from Odyssey that the judge denied the motion for a protection order against Dad. I don't know how legit her claim for a restraining order really was, but the judge didn't think it was necessary to grant one. They had a hearing scheduled for the presentation of orders, but that hearing was struck from the docket because they had already sent in a signed agreed order for the denial. This couple is really high conflict. The records show a never-ending list of show cause hearings and contempt motions, and in fact, they already have another hearing for contempt scheduled for November 12th. I wish they could stop dragging each other to court and start putting the children first, but there doesn't seem to be any end in sight to this back and forth for right now. This video will be the final update in this case. We won't be able to see the contempt hearing because this courtroom returned to in-person hearings at the beginning of November.